Welcome to Spoken Injustice, where we put the criminal justice system in the dock. Imagine it's nearing Christmas and you're getting into the festive spirit when your 3-month-old baby girl suddenly falls ill. You rush her to the hospital where doctors assure you they will do everything they can. But tragically, against all odds, she doesn't survive. Your world comes to a standstill. Amid this heartbreak, your car insurance lapses. In such an overwhelming time, could anyone reasonably be expected to focus on renewing their car insurance? The last thing you'd anticipate is being prosecuted for it, right? Yet, that's exactly what happened to Jenny. A heartbreaking example of a criminal justice system that values speed over justice. Jenny was convicted for failing to renew her car insurance, which had lapsed by just 1 day, despite her plea citing mitigating circumstances. In this video, we will explore everyday miscarriages of justice that are being perpetrated under what is known as a single justice procedure. These injustices are often dismissed as mere oversights, but which can have devastating impacts on people's life. We will explore the origin and intent behind the single justice procedure, its current state, and the growing calls for its reform. We will also compare it to a similar proposal announced last week by the Justice Secretary, this time targeting more serious offences with potential sentences of up to 2 years imprisonment. So do stay with us until the end to form your own conclusion. Before we dive in, don't forget to like and subscribe at any point during this video if you find our video interesting, to support our efforts in highlighting examples of miscarriages of justice, both big and small, as we work together to humanize the criminal justice system. A huge achievement last week. We reached the 500 subscriber milestone. I take this opportunity to thank you all. Turning to the single justice procedure. The single justice procedure is a procedure aimed at trying minor non-imprisonable offences without a court hearing and are presided by a single magistrate and a legally qualified advisor. But let's start from the basics, as we always do. Let's examine the procedure first. This procedure was established in England and Wales through Part 3 of the Criminal Justice and Courts Act 2015, which took effect in April 2015. It was incorporated into the Magistrates Court Act 1980 as Section 16A, which outlined the circumstances under which the procedure applies and its operational framework. In short, the procedure relates to summary offences non-punishable with imprisonment and applies to adults, i.e. those aged 18 or over, and now since 2022 has also been extended to companies. Typical offences include watching TV with no TV licence, failing to ensure children's school attendance, minor motoring offences, cycling on a footpath, travelling without a valid ticket. A relevant prosecutor, this may be the police, TV licensing, DVLA, the local authority, Transport for London, etc., who intends to prosecute an individual under this procedure must issue a written charge and at the same time must issue a single justice procedure notice. Both are then sent by post to the accused. The accused may respond by entering a written plea of not guilty or of guilty, and if so, including any mitigating circumstances. A guilty plea at this stage results in a sentence reduction. The accused can also give notice that they do not desire to be tried in accordance with Section 16A, in which case a date for a hearing is scheduled. If a defendant fails to respond to the notice within 21 days, the single magistrate will hear the case without any input from the defendant or the prosecutor. It is important to note, as per Section 16A, subsection 6, that the court is not required to conduct any part of the proceedings in open court. Cases are adjudicated by a single magistrate and a legal advisor, as we have said, relying solely on written evidence provided by the prosecution and, when and if submitted, those of the defendant. The magistrate can also decide whether in all circumstances before them the matter may not be appropriate to be dealt with under this procedure, and if so, they will adjourn the matter and issue a summons. Further amendments to this procedure have been made recently by the Judicial Review and Courts Act 2022, which extended the SJP to companies and which also introduced the automatic online conviction and standard statutory penalty system, a mouthful, which allowed defendants who wish to plead guilty the option to having their entire case completed online without the involvement of the magistrate's court, completely removing even that faint human oversight existent in the single justice procedure. The single justice procedure was spearheaded by the then Justice Secretary Chris Grayling under Prime Minister David Cameron in the midst of the programme of austerity promoted by the Conservative Lib Dem coalition. In February 2014, Grayling presented the single justice procedure by stating, "We must continue to look at ways to make the court system more efficient and proportionate to crimes committed. Too much of magistrates' time and court time is currently spent simply going through the motions of hearing a case where the defendant has pleaded guilty by post or has not responded. We currently have the absurd situation of valuable court time being spent on hearings where paperwork is simply read aloud by lawyers. The bill allows a single magistrate to deal with such cases away from the traditional magistrate's courtroom. It will free up valuable court time to focus on cases where they make a real difference to victims and their communities while preserving a defendant's right to request a hearing in open court." So from this we can gather that the primary aim of the SJP was to address specific challenges facing the justice system at the time. One, to reduce court backlog. Magistrates' court were facing significant delays and backlog in handling minor cases. The CJP was introduced to streamline the process and free up court time for more complex cases. To cut costs. By dealing with cases on paper without requiring defendants, prosecutors or magistrates to appear in court, the government aimed to reduce the financial burden on the justice system. And 3, focus judicial resources and increase efficiency. It was designed to handle straightforward, low-level offences so as to allow the justice system to allocate resources more effectively by dedicating court time and personnel to more serious or contested cases. While this approach promises efficiency, it has raised serious concerns about fairness, transparency, and the broader implications for those affected. Defendants often face the SJP without legal representation, as there is no provision for access to legal advice. Many defendants either represent themselves or fail to engage with the process altogether. Communication failures, such as notices sent to outdated addresses, exacerbate this problem. These can result in convictions without the defendant's knowledge or participation, undermining the principles of justice. The SJP disproportionately affects vulnerable individuals, including those with mental health issues, language barriers, or financial difficulties. These groups are less likely to understand the process or its consequences, leading to unfair outcomes. Moreover, defendants are unable to present mitigating circumstances in person. Relying instead on written submissions may fail to capture the situation fully. In some cases, the system's flaws have led to widespread miscarriages of justice. For instance, last August, a senior judge ruled that up to 75,000 convictions for rail fare evasion must be overturned due to the misuse of the single justice procedure across 7 years. Railway operators had unlawfully prosecuted passengers under irrelevant legislation. Similarly, tens of thousands of prosecutions for bus fare evasion may be invalid after last June it was revealed that Transport for London misled defendants about their rights and defence options. Returning to Grayling's remarks promoting the single justice procedure, in which he criticised the absurd situation of valuable court time being spent on hearings where paperwork was simply read aloud by lawyers, one could argue that the presence of those lawyers in those railway cases might have identified the issue earlier. This could have prevented the failures that led to 75,000 wrongful convictions. Ironically, rectifying these errors will now consume the very valuable court time that the procedure was intended to save. These criticisms have fueled calls for reform, including improved communication with defendants, more transparency in proceedings, and greater safeguards to ensure fairness for all parties involved. The point is that the consequences and ramifications of errors in these speedy procedures are far from insignificant. The standard tells us that almost 800,000 criminal cases a year, 62% of the total work done by magistrates, are handled under the single justice procedure. As per the implications, aside the sentence itself, which can comprise a fine, community order, or in cases of motoring offences can also result in penalty points in your driving license and a driving ban, there are other consequences to criminal convictions, no matter how small they are. Though it is understood that most single justice procedure notices are given for non-recordable offences, it isn't clear whether those given for recordable offences are classed as convictions and whether, as such, they end up in your criminal record. And if they do, they are subject to disclosure in almost any action on a day-to-day life. First, this conviction can appear on a basic, standard or enhanced DBS check, which have consequences in many aspects of our lives. For example, they may have employment consequences, as they can affect employment opportunities when applying for a new job, or for those in employment, particularly licensed professionals such as teachers and healthcare workers, could result in disciplinary action. They also have impact on international travel, as a criminal record restricts travel to certain countries, such as the United States. Convictions can impact applications for rental properties or mortgages, and they may increase the cost of car or home insurance, or make obtaining insurance more difficult and sometimes impossible. A summary conviction can have a cumulative effect, potentially leading to harsher penalties if the individual is then caught in the criminal justice system in the future. Once spent, a conviction does not need to be disclosed. However, there are exceptions depending on the circumstances. The recent news of Louise Haigh stepping down from government for an offence which occurred more than a decade ago and which was said to have been the result of a genuine mistake and moreover was duly disclosed, give us some reality on how convictions can affect our lives well beyond the sentence and immediate consequences. It is for this reason that charges must be carefully considered and carefully defended. There is no such thing as a minor conviction when it comes to consequences that last a lifetime. Similar arguments are now being used to propose a comparable system for Crown Court cases involving offences carrying sentences up to 2 years imprisonment, as revealed in this video released last week. Such a system could deprive individuals not only of their liberty, but also of irreplaceable moments like the birth of a child or the death of a loved one. The single justice procedure has undoubtedly streamlined certain aspects of the justice system, but its implementation has exposed significant flaws. Addressing these issues is crucial to ensure that efficiency does not come at the expense of fairness and justice, and should serve as a cautionary tale against adopting measures touted as solutions for saving court time. This is our view, and what is your view? Let us know in the comments below. This concludes our session today. I hope you found this video interesting, and if so, do like it and consider subscribing to our channel to help us in our mission to humanize the criminal justice system. Join us again as we sit and rise in this unique trial.